ordinance making power. Ordinance making power is specifically, expressly said to be having the force of the law made by Parliament. 123 and 213.
In fact, the ordinance making power would support your submission, because the fact that a power is not vested in Parliament, in this case, the legislative power, the ordinance making power, is not dispositive of the nature of the power.
Yes.
It's not the institution which wields the power, but the nature of the power which is crucial.
That's right. I'm grateful. One has to consider the nature of the power, not who is wielding it.
So, for instance, one of the exceptions to the doctrine of separation of powers is the legislative power, which is vested in the Supreme Court to frame its own rules.
Yes.
It's also regarded as legislative in character.
It is. And it is original, flowing from the Constitution, not otherwise.
Likewise, Parliament has the power to punish for contempt of itself.
Yes.
So that is, in that sense, not a legislative power. It's a judicial power which is wielded by Parliament. So according to you,
there is no absolute
370 itself is a constituent power.
Yes.
Because it's a power to amend the application of the Constitution to Jammu and Kashmir.
That's my answer. Then with regard, the other submission which I made was about recommendation. I will not repeat that why, my lord, recommendation should be considered as non-binding, but just to compare, my lords, Chief Justice had last occasion words. If your lordship looks at article money bill, of course, the lordship saw, my lord, but that's different, my lord. That goes to Rajya Sabha. Expressly mentioned that Lok Sabha is not bound.
Yes.
So money bill provisions are 109 and 198. Then there is a disqualification provisions, my lord, that is article 101 and 192. Now, please see 101. So the word is not recommendation. The word is opinion. If there is an issue of I'm sorry, not 101, 103, lords. 103. I apologize. 103. One makes the decision of president final, but 2 says before giving any decision, I am drawing my lord's attention to 2. Before giving any decision on such question, the president shall obtain the opinion of the election commission and shall act according to such opinion. Mark this last expression. So where they want that, my lord, if some other body, whether inferior or at par or superior, is not material, but of course, it is disqualification and a decision given by the election commission. But they wanted that the president should have no other discretion left. He has to act. Now, these words are not deployed in 373. Now, similarly, when we come to finance bill, that is article 117 and 207. 207 is for the state. Sub-article 1 of 117. A bill or amendment making provision for any matter specified in clause A to F of clause 1 of article 110 shall not be introduced or moved except on the recommendation of the president, and a bill making such provision shall not be introduced in the Council of States. Now, this is a perpetual provision, it's not a temporary one. And the proviso says, provided that no recommendation shall be required under this clause for moving of amendment making provision for the reduction or abolition. By the cabinet, the Council of Ministers. And the recommendation is to be made by the president, which is also Council of Ministers. Now, this is relevant, Lord, for Article 3. So our framers do contemplate situations where, Lord, the Council of Ministers is at both the ends. At one end, it speaks through the president. At the other end, it's the framer of the bill and places it before the House.
And President is acting on the advice.
In a way, it may appear to be superfluous because if the cabinet has to place it, straight away proceed because the cabinet and president in any case has to sign it and recommend. But the situations are different. Similarly, 117(3), a bill which, if enacted and brought into all expenditure from consolidated fund, shall not be passed by either house unless the president has recommended to that.
The reason why it was said that the president must recommend and not the council, so that's really what it means.
Yes.
Is because under Article 84, the parliament consists of the president and the two houses of parliament.
Yes, yes.
The parliament doesn't consist of the council of ministers because the council of ministers are all members of parliament.
That's right.
But the president is a part of parliament.
But all bills don't go through the president.
They don't. Only money bills.
Only money bills go through. So, sort of, perhaps it was intended to be an additional precaution that the president may look into it, may perhaps exercise his power under Article 75, etc., to divert it. And
so you don't specify the council of ministers because they are part of parliament. Individually, they are members of parliament.
Absolutely. Correct.
So recommendation you have shown us 109.
Now kindly see 146(2). Now this is a case, my lords, which my lords were the rules power of the court.
Yes.
Now this is not from a superior to an inferior or something else. Here the approval is required because of financial implications. (146)(2), and for High Court it is 229(2). Subject to the provisions of any law made by Parliament, the conditions of service of officers and servants of Supreme Court shall be such as may be prescribed by rules made by the Chief Justice of India or by some other judge or officer of the court authorized by the Chief Justice of India to make rules for that purpose. Provided that the rules made under this clause shall, so far as they relate to salaries, etc., require the approval of the President. It can never be argued, my lord, that if this, supposing this provides it by the route of 368 to ensure greater independence in financial matters, will the main part die, my lords? Are they rolled into one?
Yes.
So the fact that the proviso ceases, the main part ceases, and one very great argument, my lord, Mr. Gopal Shankar Narayan had raised, drawing my lord's attention to the colon. In 373 also it exists, perhaps to suggest because there is a colon, therefore they are rolled into one. Every proviso in the Constitution of India, I have gone through, Mulad, there are several provisos in various articles. All of them, Mulad, have a colon. And colon in grammatically indicates only an addition, nothing more. Every proviso, Lordship may see. In fact, in 146(1) itself, there is a proviso, colon. Nowhere your Lordship will find any other, a full stop or a comma or a semicolon. It's always colon. Because it's addition. Generally as a rider. The rider goes, the main part expand, no need for approval. And the last part of this section of my submission is that so far as Parliament is concerned, the CO 273 does not refer to 367, etc., or 356. It only says exercising the power under 373 and acts on the recommendation of Parliament. Now, Parliament, my lord, can come through the route which the Union adopted. That's one part. My learned Solicitor General has already submitted. I'll not repeat at all, my lord, on that. I adopt that, my lord, and nothing which I say detracts from that submission. But an additional submission is, my lord, that the President means Council of Minister, and Council of Minister means collectively responsible to the Parliament. So, Article 53, read with 73 and read with 75.3. Say, my lord, Council of Ministers can go to the Parliament anytime for obtaining its views. So the fact that Parliament's recommendation has been obtained, Parliament is not a foreign body. And the parliamentary rules, my lord, any issue can be brought before the Parliament, resolutions can be passed, the views can be obtained. So we need not go, my lord, in my respectful submission, of course, that stands. But independently of that, the obtaining of the recommendation is not foreign, my lord, to the exercise of power under 373. Because of these three provisions taken together.
Can you come back? Can you reformulate that?
The submission is that Parliament's opinion, recommendation or views for exercise of power under 370 sub-article 3 can be obtained by the Council of Ministers on account of the provisions of Article 53, 73, 75. Since Council of Ministers is responsible to the Parliament, so it can always go to the Parliament. In fact, Parliament laws, it's a big decision being taken. So the whole of Parliament is being taken into confidence. Instead of rushing through an executive forum alone, there the voice taken together, both the houses, the voice of the people of the whole country is heard, including the member of parliaments of Kashmir, who are also represented in the Council of States. So therefore, CO 273 is sustainable on its own. And one small aspect, Lords. Let's take the submission of the petitioners at the highest, Lords. What are they trying for, Lords? This permanence which they are seeking is for what? According to them, Lord, Ampat Prakash, sub-article 2 is already defunct. According to petitioner's submission, main part proviso rolled into one, therefore all of 3 is defunct. A, of course, 238 itself has gone, is defunct. B1, only, Lord, and B1 has a very narrow scope, Lord. Please have B1 once again. I have a slightly different take on B1. B1 is not for determining the matters irrespective of what matters have been specified in the instrument of accession are to be determined by a reading of the instrument of accession itself. Nothing can be taken away from that. That is final, sealed. What B1 is limited to discovering which of the entries are corresponding to those matters. There are matters specified in the IOA. There are matters specified in the, it only discovers the entries. There is no power at all to vested in the president to act in consultation to detract from the IO surrender. If defense is been surrendered, When it has to be exercised as per Constitution of India, wherever the power is, only the entries what has to be located. And that power cannot be controlled. You take away residuary power or do whatever. Subject matter of defense is surrendered by that, and therefore the central union government will exercise full powers with regard to communications, etc. Entry or no entry.
Because there may be more than one entry
Yes.
in the union list or concurrent list, which corresponds to a head in the instrument of accession.
That's right.
The instrument of accession was prepared at a time when the constitution was yet to be framed.
Yet to be framed.
Therefore, it used broad expressions: defense, external affairs, communications, and it had various subheads, as we saw yesterday. You showed us that.
Yes.
For instance, defense. Now, just take one example only. Defense.
Yes.
In the union list covers entry 1, Defense of India; entry 2, Naval, Military and Air Forces; 3, 2A, deployment of any armed force, which came in the 42nd Amendment;
And
4,
arms.
Naval, Military and Air Force works; 5, arms, firearms, ammunition and explosives. Yes. So it was basically what the president had to do was look at the entries in the lists and see which of these entries corresponds to what the IOA has said would be the domain of the Dominion of India.
And consultation came in for a reason, historical reason, because when cabinet mission plan was being considered, then primarily Nehru ji and the Congress itself wanted to keep it loose. And they were all the time contending that these expressions are only categories of entries, matters. It's not one matter, defense. There are a whole lot of other things. For if you want a defense, you will need finances for the defense. So he was interested in expanding and centralizing. More power to the center. So there was one thing that therefore you consult, get their views, it's okay. So consultation is a weak expression, it doesn't bind the president at all. However, that's the difference which I pointed out, that this is only to discover the correspondence. But it cannot detract from the surrender in the IOA. Now, since that has been done, this is also defunct.
Just 1 minute.
So what survives is B2 and D, proviso 2. Even the first proviso, correspondence.
Is what survives according to you is B2.
And D, proviso 2. I'm taking the case of petitioners, not according to me, but according to them.
You're testing their hypothesis.
Yes, we have to test, Lord, what is it you are gaining, Lord? What are you wanting, aiming at? You seek permanence for B2 and D, P2, proviso 2.
Sorry, just come again. B2 and D, proviso 2.
Yes. And Lord, over the course of years, almost all institutions of the union have been applied. Very little remains in B2 and D2. So permanence for that. It really leads to the principle, Lord, that we should avoid absurdity, Lord. It's a reductio ad absurdum, Lord. Lord, the second vital question which arises with regard to 370 is, what is the status of the Jammu Kashmir Constituent Assembly and the Constitution of Jammu Kashmir? If I may use JKCA and COJK. And there are two contending thoughts. Once again, the choice is between these two.
Yes.
We are saying that the source for creation and disappearance of the JKCA and the COJK, Constitution of Jammu Kashmir, is Article 370 itself. Whereas the petitioners contend that the source for these two bodies flows from the crown of Hari Singh. That is to say, residuary sovereignty, remnant sovereignty, or internal sovereignty. Three expressions have been used by three different councils.
What are the expressions?
Residuary sovereignty, remnant sovereignty, or internal sovereignty.
Shared sovereignty.
Shared, which my friend Nitya Lord used, has a different connotation. We are all sharing, Lord. We are all co-sharers of sovereignty. Every individual citizen is a co-sharer. I have no problem with sharing of sovereignty.
Residuary sovereignty.
We all share, Lord.
Remnant sovereignty, and the third?
Internal sovereignty.
Internal, yes. Mr. Dr. Dhawan said that.
And from this idea of remaining balanced sovereignty, there was a further concept introduced, bilateralism or compact. There are two sovereigns now, one remnant and one the main sovereign. So the two sovereigns are talking to each other, whispering to each other, and all that theory, and compact and bilateralism emerges. So the choice is between these two, Lords. If you accept that some sovereignty remained after the signing of the IOA, and some sovereignty remained after agreeing proclamation, Lord, that of Yuvraj Singh, that relationship between union and the state will be defined by the Constitution of India as applicable to. Then that expression is very important. You don't have to go out of Constitution of India. It is defined by the Constitution of India as applicable. Whatever it may be applicable, but it is to be found within the terra firma of the Constitution of India. This methodology, my lords, and just let us have a look, my lord, what is the Constitution of India telling them? Note two things, my lords, which are expressly in 371st. The first is the explanation. And the explanation applies to the whole of the article, not only sub-article 1. In terms, it says, for the purpose of this article, the government of the state means so and so. What is it doing, lords? One, it is substituting the Maharaj for Maharaj acting on the advice of Council of Ministers. So the monarchy is dead. The popular rule came, my lord, when he had virtually nothing left for sovereignty, my lord. And it is on that crown, my lord, which they are, the sinking crown on which the petitioners' submissions are banking. However, that crown also, my lord, Nehruji first said that you release Sheikh Abdullah and popular government. He was released. He was made the Prime Minister. And on his advice, it was not simply Hari Singh, it was both the popular government and Hari Singh, Lord, who agreed to the accession. So the people's voice was also there. And the explanation leaves no room of doubt that the Maharaj is not to act on his own view, opinion, discretion, but act on the advice of Council of Ministers for the time being in office. Second, my lord, even the Maharaj has to be recognized, that person who is recognized by the President of India. So when Yuvraj, my lord, issues the third proclamation in 1951, that is after the Constitution of India came into force, he was acting on the advice of the popular government in terms of the explanation to convene, to constitute and convene the JK Constituent Assembly. The next question would be, my lord, what is it? For what purpose are you constituting? And the purpose is spelled out by sub-article 2. So the Constitution envisages that this assembly is for the purpose of framing the constitution of the state. The third thing, my lord, is in framing of the constitution, the JKCA is does not enjoy the freedom which the Constituent Assembly of India had. It was bound by several things. First, it was bound to frame the constitution in a manner that the sovereign democratic Republic of India, that's not adversely impacted. And at the moment, I'm not relying upon the doctrine of basic structure which came later. But even as it stood in 1950, 26th of January, this constitution of JKCA could not detract from it and has not. It had to ensure justice, liberty, equality, fraternity. The contours of lawmaking are specified on account of the sheer accession. It was also bound by Article 1. It could not declare that we are not the federal unit of India. And it accepts in that dictat of the Constitution of India in Section 3. That's not their own framing. They are bound to do it. Next, my lord. They could not therefore say that any part of their territory will not form part of the union territory. That is 1.3. They could not also say that every person domiciled in the territory of India, and your lordships have held, my lord, I'll give that judgment where lordship said there's only one domicile. Every state does not have a domicile. Nobody can say I'm domiciled in UP or Tamil Nadu or Bihar, etc. So they could not say that the people who are, that is the permanent residents of Jammu and Kashmir, will not be the citizen. And they accept that, my lord, in Section 5. That's not a gift of JKCA. That's the gift of the Constitution of India and the dictation of the Constitution of India to them. The same applies to the fundamental rights. Every citizen, see the concatenation and the connection between these provisions. 1, 5, Part 3, which says every citizen. In fact, some of the fundamental rights are broader, but 19 specifically citizens. So these rights could not be denied, and therefore they rightly will not follow it, the dictat will not, and put it in Section 10. Even if it was not there, my lord, they would have enjoyed these fundamental rights under the Constitution. And neither the president acting, my lord, under 370, nor the authorities, my lord, who are giving concurrence or consultation or recommendation could say that apply 370. That's not the purpose of the recommendation, is very narrow. Continue operation, don't operate, or operate with some little modification. So therefore, my lords, these fundamental rights, etc., and they also could not say, and they have wrongly, my lord, gone into that in my humble submission when they said that Article 136 initially of the Supreme Court's power will not apply to Supreme Court. They could not say that. Because in the accession, my lord, they have said we accept the Governor General, which will be President now, the federal legislature, that is the Parliament, the federal court, that is the Supreme Court, and other authorities, my lords, who are under the Constitution charged with certain functions. The power to fix terms does not mean, my lord, that you take away the power of these authorities under the Constitution. But things have been happening, my lord. 35A has also come, 136 had gone. That to deprive 136 to the people of Jammu Kashmir, my lord, is a huge denial to them. So in short, my lords, the framework of the Constitution of India, and when we look at JKCA, we find that the entire JKCA is a reflection, my lord. There's nothing peculiar in that, my lord. What is peculiar is 147 when it says that you can't amend the Constitution. There are restrictions. Likewise, Section 5 says that whatever be the Parliament's power under the Constitution of India, So throughout it follows the diktat and respects the Constitution of India, and there is very little in it which is different. This methodology which has been adopted by the Constitution of India for the formation of JKCA, its convening and its enforcement, in my humble submission, is very akin to the juristic concept of devolution of powers. Devolution of powers. The Constitution has devolved power on the Yuvraj, then acting on the advice of Council of Ministers, to convene for the purpose of framing the Constitution in accordance with the broad format, as I pointed out. It's not an independent power like the Constitution Assembly of India. I'll give to your Lordship, in view of the time constraint and these two judgments, this concept is frequently applied, Lord, in United Kingdom. Scotland, Northern Ireland, Wales, all of them are enjoying devolved powers. The Parliament of UK is considered to be supreme. There, of course, that is somewhat different in the sense that the law made by UK Parliament for Scotland specifies not their Parliament. So we have Scotland Parliament also, Northern Ireland Parliament also, and the Wales Parliament also. So it doesn't matter that you call your person Sadar-e Riyasat or Prime Minister or Chief Minister, the stature doesn't expand by these expressions. The stature will depend upon the nature of power you are exercising. It doesn't equate with the power of Prime Minister of India, even if you call them Prime Minister. Yeah, psychological and emotional reasons apart. So the two cases, Lord, they are not on record, so I will not place it, Lord. The time bar is there. I'll just give the reference and paragraphs through your Lordship, Lord. Huh? I was not admitted. We did send it, Lord, but it's not admitted, so it's up to your Lordship.
What are the two cases? You can give us a citation.
I am giving the citation. 2002, Volume 1.
What's the name of the group?
The name of the party is In Re Scottish Independence Referendum Bill. In Re Scottish Independence Reference Bill 2022, I'm sorry, 2022, yes. UK SC 31.
You repeat the citation again?
Paragraph.
Can you repeat the citation, Mr. Nehru?
2022
Yeah.
UK SC page 31. Para 76, 77, 82, 88, and 90.
Yes.
And how can you just sort of summarize in a sentence what the principle is?
The principle was, Lord, that in this case, they wanted a second referendum. Sorry, when the Brexit was happening, then they wanted to continue relations with Brexit. So it was impinging upon the sovereignty of the parliament. In that context, they have discussed this devolved powers. And they say that the parliament gives the power and parliament can take the power, it can modify the power. So the parliament is. So this power is also a devolved power of a different kind, of course, because it's more general. It's not itself framing like other states what they are to do. They don't have the list too. So it's a little more. So that's the departure. So you have the psychological satisfaction of.
And what is the second judgment?
Then the other is 2000. This is case is UK withdrawal from European Union. 2019, 2018, UK SC 64.
2019 or 18, you said?
18,
Yes.
UK SC, page 64. Paragraph 12, 13, 29, 53, 61, and 63. Now, in this context, Lords, kindly just keep my written submission open, Lords. It's in the combined. I have tried to extract things there, Lords, so that I don't have to request your Lordships to open the document as far as possible, Lord. The other aspect, Lord, Nehruji himself says that the idea of having a constituent assembly for framing a constitution for the state emanated from the government of India. And that is, your Lordship will find in para 128, page 44 of my submission.
It's in which volume?
Well, this is the combined compilation, volume 3 written submission.
Volume 3 is Mr. Solicitor's, no? Mr. Tushar Mehta's, right?
All
It's in that.
submissions are there.
Oh, I see.
All submissions are there only.
Right, but that's in volume 4. We got it. Yes, we got it.
It starts at page 271. Oh, sorry.
Volume.
Kindly come to the last 8 lines, notes.
Of which page?
It will be, notes, paragraph 128 at page, PDF might be 44 minutes.
Not 44.
Para 128,
Of your submissions?
submission.
Where do your submission start from? Which page?
They start at page 271.
Yes, it
What's
starts
your
from
internal page?
271,
What's your internal page?
page 44.
That will be about 313, I guess.
PDF 316,
What's the paragraph number?
128.
Yes, it's page 316.
Okay, hold on to it.
If towards the middle, you shall find, thus the monarchical power had disappeared. The Lordships have got this one? Hello, Justice
Yes.
Surikant.
Yes, sir. 1 second. What page is it?
Hello, Justice Gawai has got this?
Yes, para 128.
Yes, sir. I'm grateful.
Judgment? Para 128 is from a judgment, it appears.
No.
It says Sri Nafri Learned Senior Counsel.
That was, we are responding to the submission of Mr. Nafri.
Oh, all right.
They were all saying, Lord, that the Maharaj has formed, how he will form the JKCA, and
Let's quickly go through that.
Lordship may have the middle, Lord, only.
Yes.
Thus, the monarchical power had disappeared with the advent of the Constitution of India. Maharaj Karan Singh merely.
Just one second.
I'm so sorry.
Monarchical power.
Yes. Thus, the monarchical power had disappeared with the advent of the Constitution of India. Maharaj Karan Singh merely executed the mandate of the Constitution of India embodied in Article 370. Secondly, speaking in the Lok Sabha on 26th of June 1952, soon after the proclamation of Maharaj Karan Singh dated 1/5/1951, Prime Minister Shri Jawaharlal Nehru said, "So the government of India and others put it to them, to the Maharaj and Sheikh Abdullah, as soon as he came out, that this matter must not be hurried. And it was our idea then that a constituent assembly should be elected in Kashmir quickly and as soon as possible to decide about these and other questions. So we advised them." So in view of 370, and perhaps not because of the international situation regarding Kashmir, which was developing, the government of India wanted that it should be convened, there should be a ratification of accession and all that. That's the idea came from here, not coming from them, my lords. What was Maharaj Hari Singh wanting, lords? He contemplated a national assembly. He was still dreaming of independence. So he was thinking that when the whole of the POK, etc., comes in, then there will be plebiscite and then we will decide whether to accede or not. And that's the mischief which Mountbatten played when he wrote reply letter when he said that our policy of our government is, who is he to write, my lords? He is bound by the Government of India Act and the adaptation order, which says that once the Governor General accepts the accession is complete. And Indian armed forces are there driving back the people who had come inside to grab Kashmir. But he writes a letter, my lords. Governor General directly writing a letter. Policy of our government is that letter has no meaning. Mr. Sibal referred to that letter to draw some sovereignty, my lords, etc. That still looks sovereignty remained. Accession was still a dispute, still to be settled. It's not final. So where are we to go? To what extent, my lords? So what Hari Singh contemplated was completely different. What Karan Singh proclaimed was our relation will be defined by the Constitution of India as applicable to you. The two different contrasting expressions used there.
What remains, Mr. Vedi?
Because a lot remains. Because we will, sum total, we will not be crossing the boundaries, but these aspects need to be placed before our lordships and have not been placed. Now, my lords, the question is, what did they refer to? Mr. Sibal started from the cabinet mission plan, return of paramountcy. Then, when the British left, all Indian states became independent. They were free, my lords. Many felt so. From there, my lord, the sovereignty element is being derived. What is forgotten is that cabinet mission plan was again a British device to frame a larger Pakistan within India. Three groups. The central provinces, Group A. Northwest, Group B. Assam and Bengal, whole of it, Group C. Something which even Muslim League did not demand, the British were framing. Because they wanted Lord to control the two frontiers for geopolitical reasons. They want bases at both the ends. So they came with this cabinet mission plan. And it was basis was that parties are not agreeing, therefore we are presenting arbitrators. And what was the dispute? It was the first great interpretative exercise where the fight was, are these groups frozen? They provided an expression that once each group will frame a constitution, and once the constitution is framed, then the provinces which are part of the group may decide to remain or to go out of the group. Then the leaders who were leading on the side of the Congress, they said, no, these groups you may form, but once it is formed, then the provinces need not wait. And they will, so the huge fight not about the frozen character of the groups. And the other issue was parity at the center, weak center and parity. Parity, Congress, Muslim League, and the princes, three. So who controls blood? As we say in the Bandarbat blood, the British becomes the arbitrator. There will be stalemates on every issue. Now this creates a larger Pakistan. The option was partition. Now this went on. Our Constituent Assembly was constituted under the plan. So we decided to work out the plan, but without being bound by the cabinet mission plan. And it was made very clear by our leaders that once Constituent Assembly starts, then what it decides is not your concern. It may choose to destroy the groups also. In fact, the leaders were called to London also, and they said it may be referred to federal court in case of dispute, but our acceptance will remain qualified. Now, 26th, 9th of December, 1946, our Constituent Assembly started functioning. Temporary chairman, Dr. Rajendra Prasad, again, objective resolution placed on 13th of December, debated, accepted and adopted on 22nd January 1947. All this is happening before 15th of August. Then they proceed to form a negotiating committee to negotiate with the states and based on the cabinet mission plan which the princes had accepted. Please note Section 8 of the India Independence Act recognizes that the Constituent Assembly of India is that which began functioning on 9th of December 1946. There may have been a withdrawal of the British legally and physically on the 15th of August, which we celebrate as our Independence Day. But our independence is not a grant of India Independence Act. It is a result of the long drawn people's struggle. That's why we the people has come. There are some observations in Justice Beg's judgment, Lord, in Indira Gandhi's case, which the other side relied, but I found some other observations which say that independence was granted by the India Independence Act. India Independence Act, what does it do? There shall be two dominions. It is partitioning and providing an interregnum arrangement what will happen in between. Namely, the Government of India Act continues with adaptation, etc. And that the Constituent Assembly will also function as the Legislative Assembly. That is also provided in. So it's a machinery act, a transition act. It's not an act which grants us. They say dominion. Somewhere, my lord, expressions of dominion are still lingering in our constitution. My lord, the Attorney General and the Solicitor should take care that they are deleted. There are some provisions where still the word dominion continues. But we did not accept the dominion. Here comes the role, my lord, of the objective resolution. It said we are adopting an independent democratic republic. So the negotiation with the Indian states are based on the concept of republic. And since our assembly continues based on that objective resolution from 9th of December 1946, therefore, this republican character is the basis for accession. This is important for the reason, if you compare Section 5 and 6 of the Government of India Act 1935, it talks of a different kind of federalism, a federalism under the imperialism, a federalism under the crown, and a federalism which will be triggered by the decision of His Majesty. Provided more than half almost of the princes agree then to come in. So a different kind, accession, signing of the instrument of accession under the Government of India Act is different from signing of the instrument of accession under the Constitution of India in the making or under the Government of India Act as adapted. My lord said, notice the expression union, unity. There is some very vital document, now my lord, the British government has released several volumes of transfer of power, having about total of 13,000 pages. I was able to get this document, which is annexed to my written submission. Kindly have a look at that. It completely changes, and all these documents were not present, my lords, in the earlier exercise relating to 370. PDF paper. PDF page 327. Lordship has this?
Yes.
My Lord Justice Call has this?
This volume 11, the Mountbatten. Is that what you're reading in extra 2?
No, I'm on the same written submission, my lord, which I was reading
Yes,
earlier.
yes.
Yes.
That's the
327 begins with
Volume
the
3.
constitutional relations between Britain and India.
Yes, yes. May I place it? My Lord the Chief Justice,
Yes.
please read below the caption, section 5 of the Act. A revised draft.
Where do we, the page 327 is the title page.
Next page, Lord. Page,
Next,
running page 70.
that is 8 June 1947.
The letter of 8th June
Mr.
1940.
Rajgopalacharya to Sir S.
No, Lordship, go ahead. That's I'll come to that letter later, my lords. Please come to running page 73. Oh,
Where is Mr. Kanu Agarwal?
sorry, PDF 334.
PDF
334. I'm so sorry.
334.
Achha. All right, then got it.
334 is a part of some document, I guess. What is that document that this is a part of?
Oh, that's some earlier letter, my lord.
Enclosure number 1 to number 111. The disappearance of paramountcy, the emergence of independent sovereign states, and the balkanization of India by Sir Allah.
PDF 345.
345. 1 second. Give us a moment.
Three, four, five meetings of the Indian cabinet.
Yes, yes. Meeting of the Indian cabinet. I'm grateful. May I place that, first? Meeting of the Indian cabinet.
Yes, 345. Actually, this is a part of volume 12 of the transfer of transfer of power documents. And now we have
Oh, hell's no, you'll be told.
page 345, which is meeting of the Indian cabinet,
That's right. May I place it?
Mountbatten papers, Indian cabinet minutes, part 2.
Yeah, the Indian Provincial Constitution Order 1947 was being discussed. The Honorable the Vice President recalled that in the discussions at the previous meeting of the Cabinet on the India Provisional Constitution Order 1947, two sections, namely Section 5 and 47, had been left over for further consideration. Section 5. A revised draft attached, prepared by the Reforms Secretariat in the light of the previous week's discussions in the Cabinet, was handed to the honorable members. It was pointed out that there was the same fundamental objection to the draft as now revised as to the originally redrafted Section 5 of the Act considered at the previous meeting. The draft gave the impression that the dominion was limited to British India, which was an entirely wrong conception. It was necessary to devise a formula to show clearly that the Dominion of India would comprise A. Governors' provinces, B. Chief Commissioners' provinces, C. Such Indian states as acceded to the Dominion, and D. any other areas which by consent of the Dominion would be included in the territory of the Dominion. Now, this is important. Political and psychological considerations demanded that there should not be the least doubt that all states that acceded to the Dominion would form an integral part of the Dominion. This is how, my lord, the reason for changing, my lord, the earlier draft and, my lord, Section 5 and 6 of the Government of India Act. So, my lord, the cabinet of the Government of India, now the whole thing changes, my lord, with this backdrop. If you read the IOA which was signed, it was a formatted document. Everybody signed. So all those mergers and etc. which are being talked about, my lord, they are neither here nor there. They are just a methodology. Mergers are generally happening, my lord, of small states to the next door state or, my lord, union of states which they formed. That has nothing to do with. Now, some states have accepted the Constitution of India, some may not have said so. That's once you sign, that's the last. You become an integral part of India. With this adaptation order before the Indian states, the rulers signed the instrument of accession. So therefore, every state which signed, so far as it's becoming an integral part of India. And in fairness, Mr. Sibal concedes not that JK is fully integral from that point of time. But it has consequences. So when Article 1 talks about, my lord, merger of territory, when it talks about including the state, it is not just off the cuff. That's the mandate flowing from the statute, accepted by everybody. Everybody is acceding on that basis. So it's an understanding. Therefore, my lord, all these states are mentioned in the schedule. And their territory is incorporated. That's the integrity. And the instrument is at page yes. That is at PDF 350, which your lordships have seen in the other volumes. Your lordship may just note that in the very beginning it says, Dominion of India established by the India Independence Act shall, as from 15th August, be a union of, that's the first clause is the amended draft. Section 5. And please see 5C, Indian states acceding to the Dominion in the manner hereinafter provided. So if you accede in the manner under Section 6, you become part of the Union. This is also there in volume 6, PDF 103. And 6A says, if you declare that he accedes to the Dominion with the intent that the Governor General, Dominion Legislature, Federal Court, other Dominion authorities established for the purpose of Dominion shall, by virtue of instrument, but subject to the terms thereof, and for the purpose of the Dominion, modifications or qualifications which may come in, but you can't say that on the one hand that I accept the Supreme Court, I accept the President, I accept everything, but qualification, I will not accept 136. The adaptation orders to make it clear to all the rulers of the states that the moment you sign the instrument, you are part of the union, you are integral. So
actually, if you see the Constitution, the Provisional Constitution Order of 1947,
yes,
which is a part of Mr. Arvind Datar's second edition of 2007, schedule now at page 350,
Yes,
there you will find the modification of Section 5.
that's right.
The Dominion of India established by the Indian Independence Act shall, as from the 15th of August 1947, be a union comprising of C. The Indian states acceding to the Dominion in the manner hereinafter provided.
That expression is very important, in the manner.
In the manner. And now 6 says accession of Indian states.
Yes.
An Indian state shall be deemed to have acceded to the dominion of the governor if the Governor General has signified his acceptance of an instrument of accession executed by the ruler, whereby the ruler on behalf of the state A declares that he accedes to the dominion with the intent that the Governor General, the Dominion Legislature, the Federal Court,
Yes.
and any other Dominion authority established for the purpose of the Dominion shall, by virtue of this instrument of accession, but subject always to the terms thereof, and for the purposes of exercise in relation to such states such functions as may be vested in them by or under the Act, assumes the obligation of ensuring that due effect is given within the state to the provisions of this Act, so far as they are applicable therein by virtue of the instrument of accession.
Now, B completely destroys the argument of internal sovereignty. You have to give effect to all these authorities, the laws made, the execution done, the judgments given within the state.
I have retained my sovereignty for the
You
future.
see, Section 6, which is amended, does not contain any such term. Rajas cannot, as the learned Solicitor General showed, somebody is saying that we will have reservation about tax, so that's their wish. You may wish anything. But so far as the statute is concerned, as adapted, Section 6 does not contain any Clause 8. All that remains is that by supplementary instruments, you can further make more concessions. You may concede more subject matters. That Clause 8 is completely beyond 6. It has no validity. But I will say, you read that Clause 8 of IOA where Hari Singh says, I preserve my sovereignty, that is only meaning that he is preserving his power to legislate and do whatever with respect to the remaining subject matters.
Right. What's the next point, Mr. Dwivedi? We'll have to leave some time today for Mr. Giri. So long as all of you are within the time framework, we have no problem.
But our time should be up till Monday, at least.
Monday afternoon, Monday lunch.
So we'll try to finish by that. It won't.
Monday lunch is the final time.
Ordinary may not be a spill at all, but
we were hoping that
the learned councils have agreed that I must.
Monday afternoon we have to, so that then we can give them the rest of Monday and Tuesday to complete the rejoinder.
So we'll, as I said, we'll try to.
Mr. Giri, 45 minutes through lunch, and we wrap up.
We'll finish by 12 minutes instead of stopping Mr. Giri,
No, but
we'll finish.
Primarily now, the main council are to follow you, Mr. Giri, Mr. Mahesh Jetmanani, and Guru. Right? So the others, look. One second, don't interrupt. I'm in charge of the proceedings. We have to, these are the three seniors. Now, after this, we'll have a lot of interveners, etc. But what is to be said has been pretty much said. We'll request all the interveners to please talk to the council who are following Mr. Datar. Whatever they have to say, they may indicate to the council who are now going to argue, so that the four council will cover the entire gamut. I think that would be a very fair way of doing it. And then we'll hear the interveners for 2 minutes or 3 minutes.
That's right.
So please, 1 second. This is now a procedural, this is a procedural mandate now, which is that all interveners who are going to follow will talk to Mr. Giri, Mr. Jetmalani, and Mr. Guru. And whatever you have to say, please tell them to say it on your behalf. They will not be charging a separate set of fees, and we will conclude with that. I think that's the only way. Now, tell us, Mr. Dwivedi, how long now?
We'll finish, our side will finish by lunch, Your Lordship, because otherwise,
All right. Do we take that, that between Mr. Giri, Mr. Jetlani, and Guru, you have bifurcated the time with Mr. Dwivedi? Do we take it so that you're finishing by lunch on Monday?
On Monday.
Yes. So.
It's just that
Whatever remains, one second, whatever remains after Mr. Jetlani, Mr. Giri, and Mr. Guru Krishna Kumar have completed, we are here to hear you until lunch, but we will not hear the respondents after lunch.
Discussion and two implement application on behalf of.
Fair enough. We have no difficulty. After we've given you the names of people who are going to argue. After they have finished, if there's some time remaining before lunch on Monday, we will hear you certainly. But after lunch, that's it. At 2 o'clock, we call upon Mr. Sibal to start the retirement. Oh, I'm so sorry. Nothing now. We have to now. We'll have the whole country wanting to argue here, but now that's all right. That's all right. That's all right. Yes. You sit with the seniors who are arguing after. There has to be some order. You can sit with the seniors in during the course of the weekend, and you can talk to them. If somebody has a point, please tell them. Yes.
let me
adhering to what your lordships have indicated.
Absolutely.
Right.
Can the intervener circulate a short note?
No difficulty. Absolutely. A page at the most.
because
Lord, some of them have taken a lot of invested a lot of time, passion.
But of course, we don't deny that. But then presentation has to be through either these seniors who are arguing have to curb themselves, or then we have to just do what we have to do.
We'll abide by the timelines that your lordships have indicated.
kindly just note the documents. I will not read now because of the time constraint. Your Lordship will look into it. Just at PDF 328. This is about the paramountcy. What was the view of the leaders on the Indian side when they were discussing? None of these Indian states were independent, really.
Mr. Dwivedi, we have understood this argument.
Yes. I'm not reading before. I'm just saying, Lord, Your Lordship may note the first is Raja Gopalacharyar's note. The second note, my Lord, is at page PDF 331, which is Sri Aladi Krishna Swami Iyer, my Lord. And they took lot of pains and the last, my Lord, is of Pandit Nehru himself, my Lord, at 339. To Lord Ismay, who was the Chief of Staff of Mountbatten. All three of them, my Lords, they were persisting that they have never been independent. What are you doing? This return of this paramountcy was an attempt to balkanize India, create so many enclaves, and that created so much problem. And it is thanks to Sardar Patel's, my Lord, that all this was quick. And when he left, he was wondering, my Lord, that what he was trying to negotiate on 3 subjects. And Sardar Patel, he said that you have wiped out the monarchy from the map of India. So therefore, my Lord, they were hardly independent. And we know from Amritsar Treaty, my Lord, on the basis of an amount of money and 1 horse and 12 shawls, etc., which is mentioned in the next document, I will not read it. It was transferred to Gulab Singh, and that's how this. So when were they? Earlier under Ranjit Singh and some king or the other, they were never independent. So that's the. So therefore, this sovereignty flowing, internal, residuary, whatever, there was no sovereignty. And whatever left, Article 1 finishes. That's the complete merger. No merger agreement is required. No supplementary instrument of accession is required. Now, Lords, in Re Berubari, kindly read. I am reading only from this note, para 73 of my written submission, which is at page 298. Philosophy, has it?
Yes.
Now kindly come to PDF 299. The bold portion. Cession of national territory in law amounts to the transfer of sovereignty over the said territory by the owner state in favor of another state. There can be no doubt that such cession is possible, and indeed history presents several examples of such transfer of sovereignty. It is true, as Oppenheim has observed, that hardship is involved in the fact that in all cases of cession, the inhabitants of the territory who remain lose their old citizenship and are handed over to a new sovereign, whether they like it or not. And he has pointed out that it may be possible to mitigate this hardship by stipulating an option to emigrate with such certain period in favor of the inhabitants of ceded territory as means of averting the charge of the inhabitants are handed over to new sovereign against their will. But though, from the human point of view, great hardship is inevitably involved in cession of territory by one country to another, there can be no doubt that a sovereign state can exercise its right to cede a part of its territory to a foreign state. This power, it may be added, is of course subject to limitations which the constitution of the state may either expressly or necessary implication impose in that behalf. In other words, the question as to how treaties can be made by sovereign state in regard to cession of national territory and how treaties can, when made, can be implemented would be governed by the provisions of the constitution. Stated broadly, the treaty making power would have to be exercised in the manner contemplated by the constitution is subject to limitations imposed by it. Whether the treaty can be made implemented by ordinary legislation, constitutional amendment will naturally depend on the provisions of the constitution. Then, kindly come to the next overleaf, my lords. Last few lines of this paragraph. We have already referred to Article 13C, and we have observed that it does not purport to confer power on India to acquire territories. It merely provides for and recognizes automatic absorption or assimilation into territory of territories which may be acquired by India by virtue of its inherent power as a sovereign state. So that 1C and 2, they are straightaway act of state. So even Constitution can recognize by its provisions certain powers which are in the nature of act of state. It may circumscribe it or it may not circumscribe it. Now kindly also have 74 Santosh Gupta, my lords. This was read out by Mr. Nafre, but he said this is obiter. State of JK has no vestige. This is judgment. State of JK has no vestige of sovereignty outside the Constitution of India and its own constitution, which is subordinate to the COI, Constitution of India. It is therefore wholly incorrect to describe it as being sovereign in the sense of its residents constituting a separate and distinct class for themselves. Residents of JK, we need to remind the High Court, are first and foremost citizens of India. Now, this is not obiter. I have explained in 75. My lords will look into that. There were direct questions in the High Court judgment. It was said that JK is sovereign, and therefore their lordships dealt with it and said that that sovereignty is not there. It had lost its sovereignty. Then I have quoted the speeches, my lords, from Shri Nehru, my lords, and Dr. Ambedkar in para 76, 77, 78. Your lordship may just note, my lord, each of them are saying that, I may just read 76. Shri Jawaharlal Nehru said, we accepted it, and of course the accession was complete. It was not a kind of partial accession or limited accession. The accession was complete. But we said that we will abide by the verdict of the people whenever the chance or the opportunity comes. He also said, so Kashmir obviously is a constituent unit of the Federation of the Union of India. But a difference has arisen, subsequently arisen, you please remember that, not originally, between Kashmir and the other states, because subsequent to the earlier accession, the other states have become integrated more, which Kashmir was not and could not in the circumstances, as I have tried to point out. But nevertheless, it is a whole constituent unit of India. Various things flow from it, various consequences. Consequences, for instance, in regard to the President of the Republic, But the president's ultimate right has to remain for a constituent unit of India. So various consequences I already spelled out on what follows from the integration and unionization. And Dr. Ambedkar also said, this has been read by the learned Solicitor General, lost me just note. He explained what is meant by union. And kindly turn to next page, Manoj. I'm not relying so much. I've quoted though Rajaram Pal, which says destructible units and all. Maybe some lines need to be drawn. It can't mean that all the states disappear and federalism disappear. So that was your lordship's worry also when the learned solicitor was arguing about Article 3. Then para 80, the state of West Bengal versus Union. It expressly says that the feature of a compact or agreement between independent and sovereign units are absent in the Constitution of India. There is distribution of powers, but distribution of powers is not always an index of political sovereignty.
Where is this? Oh, yes, para 80.
I'm reading from what I have said, but this is part of the judgment. Para 25 I mentioned. The lordship may note that. In para 80. Then kindly have paragraph 51 going back a little. Para 51. That is PDF 293. Same written submission. Yes, Bros, I am sorry, Bros. This para 25 of State of West Bengal is fully quoted, Bros, beginning at PDF 291. And your lordship will find the relevant portion in clause A. Okay. Kindly come to PDF 292. PDF 292. This is a paragraph 25. From fourth line, the result was a constitution which was not true to any tradition pattern of federation. There is no warrant for the assumption that the provinces were sovereign, autonomous units which had parted with such power as they considered reasonable or proper for enabling the central.
Where? Page 291, PDF page.
PDF 292.
291 it starts.
Yes, it starts in 291.
There is no warrant for the assumption?
Yes. There is no warrant for the assumption that provinces were sovereign, autonomous units which had parted with such power as they considered reasonable or proper for enabling the central government to function for common good. The legal theory of the constitution was the withdrawal of resumption of all powers of sovereignty into the people of this country and the distribution of these powers, save those withheld from both the union and the states by reason of provisions of part 3 between the union and the states. A truly federal form of government envisages a compact or agreement between the independent and sovereign states to surrender partially their authority in their common interest and vesting it in the union and retaining the residue of the authority in the constituent units. Ordinarily, each constituent unit has its separate constitution by which it is governed in all matters except those surrendered to the union. And the constitution of the union primarily operates upon the administration of the units. Our constitution was not the result of such compact or agreement. Units constituting a unitary state which are non-sovereign were transformed by abdication of power into a union. Then the second characteristics is supremacy of the constitution which cannot be altered except by the component units. Then C, distribution of powers between union and regional units. If your lordship, the fourth is supreme authority of courts to interpret the constitution, that is D. Kindly come below that. In our constitution, characteristic D is to be found in full force. A and B are absent. there is undoubtedly distribution of powers between the union and the states in matter legislative and executive. But distribution of powers is not always an index of political sovereignty. So this theory, which bilateralism, compact, and all this objective resolution was unilateral, adaptation was unilateral, Article 1 is unilateral, 370 is unilateral. So there is some exchange of thoughts and agreements to be within the fold of 370 does not make it bilateral. So bilateralism need not be introduced in 373. Kindly have para 51 next page. Even in a pre-constitution setting in Pramod Chandra Deb versus State of Odisha, para 17, a constitution bench of this court held that sovereignty of erstwhile ruler ends with cession of territory. And when this court said some sovereignty is retained after the execution of IOs, that was a passing reference as sovereignty was being discussed in the light of an old grant of land by ruler to son. Such grant would amount to law which was continued post 1948. So the rights under the said grant were recognized by the new sovereign power. And Indri Beruvari also takes the same view in para 31, which I had already read. So cession of territory is a very vital and Article 1 therefore declares the end of, and if any doubts remain, that's the last nail in the coffin of sovereignty. And it is surprising, Lord, that my friends on the right, Lord, wedded to democracy are seeking permanence based on a crown which is long gone. The king is dead, long live the king. The Lord should just note, Lord, in para 69, just even anger. Shri Anger also says that they are fully integrated. We can't extract some paragraphs here and there, Lord, and assert based on 2 paragraphs what is the meaning of our clause 1, 2, and 3. Page 26. If you shall come in that paragraph 68, next page, that is 298, PDF 298. The draft Article 306A was placed before the Constituent Assembly on 1710 and passed on the same day. The Anger said, the meaning of accession is that at present day, the state JK unit is a unit of a federal state, that is Dominion of India. Dominion is getting transformed into a republic, which will be inaugurated on 26th. JK state therefore has to become a unit of the new Republic of India. He goes on to say that instruments of accession will be a thing of the past in the new constitution. The states have been integrated with the federal republic in such a manner that they do not have to exceed or execute a document of accession for the purpose of becoming units of the republic, but they are mentioned in the constitution itself. Now all this is left out and you extract 3 paragraphs where he is trying to say very lightly, Lord, about referring to clause 1, 2, and 3. And he doesn't say, Lord, what happens after the JK Constitution Assembly, Lord, ceases. He could not have said, Lord, the times were so difficult. Therefore, Lord, it is a very brief speech. But these are much more vital expressions in his speech. You don't have to exceed or execute a document of accession for the purpose of becoming units. The preamble and the Article 1 and 5 and fundamental rights, all they complete. That's the republic. Without it, there is no republic. So, my lords, that's in my dispelled submission, my lord. My submission with regard to this. I don't wish to, Lord, add anything about 356, etc., Lord, except to say that, Lord, in Bommai's case, There are two observations with regard to the width of this suspending power. Paragraph 271 and 281. I'll give it in a piece of paper, my lords, the paragraphs without detaining your lordships. 56 invocation will be in variety of situations which cannot be in variegated situations. So therefore, what will be the circumstances, emergency provision, or will depend. So I just wanted to point out to supplement Lord, those paragraphs which I'll give. And one more thing, Lord, that's a Constitution Review Committee was constituted under the chairmanship of Venkat Chellaiah, my lords. And 356 was an issue whether it should be retained, or he said this is the bulwark of the Constitution. So the concept changes with time. Initially, it was thought it will never be exercised, but the review committee says, and a very high-level committee, Justice Jeevan Reddy was also a member of that committee. And they say that is a bulwark, but yes, there has been some abuse. Therefore, the checks and balances, the adjudicatory powers, the judicial review is there to check it. So with this, I will conclude and say, that let us bury 370. 35A, Lord, I'll just, my friend has filed a writ petition also questioning, Lord, 35A. So I just wanted to give, Lord, your lordship, which again I'll mention, Lord, in the piece of paper, the paragraphs of IR Kolho, where your lordships have held that this, if you come out with any instrument of law, with constitutional amendment, which that was in the context of 31B, Vaman Rao and in Minerva Mill and all those were considered, and the lordships have held that all laws which are placed in 31B will be tested. And so far as certain, of course, prospective overruling, etc., is a different concept. But here we are finding that 35A has been super added. It's a complete lock, stock denial of several vital fundamental rights. So in view of IR Polo, I submit that needs to be struck down. I'm grateful, Lord.
Thank you, Mr.
May it please, Your Lord, I beg to appear for the applicant in IA 139743 in writ petition 1070 of 2019.
Is that, Mr. Giri, the IA number?
Lord, the IA number is 139743. Lord, the All India Kashmiri Samaj
In
writ petition number 1070 of 2019.
IA is filed which year?
Lord, the IA is 139743 of 2023.
23.
In writ petition number 1070 of 2019. But I'll just
Yes,
Lord, areas which are covered, my Lord, by the learned attorney, the learned solicitor, and thereafter by Mr. Dwivedi, my Lord. Lord, I'll just say what has been covered, and therefore I don't have anything more to say on that. But, my lord, this is essentially my lord, it's stressing on certain aspects, my lord, which I think will be of assistance in making out a case before your lordships. My lords, the instrument of accession, my lord, is dated 27/10/1947. And that is at PDF 9 of Volume 1. My lords, what happened in the thereafter, my lords, in chronological order, I'll be obliged if your lordships kindly have a look at the proclamation issued by the Yuvraj Karan Singh in Volume 3 of the written submissions, the compilation of written submissions of the respondents at PDF page 44, part of the list of dates, my lord, of the learned solicitor. Page 40.